NACDL is the association of the nation's criminal defense bar.
Welcome. Credits without karma. No, credits without contact. Welcome. I'm Laura Sheely. I'm your host. We have a great guest today. During this horrible pandemic, I certainly hope all of you are doing well. I hope that what we're trying to do with the NACDL, bringing you the credits without contact, is going to be helpful through this time. I hope I'm very appreciative to the NACDL for bringing this series to you. I'd like to thank them. I'd like to thank Gerald Lippert for putting all of this together. And I would like to welcome my guest, Stephen Alexander, who is with Trace Digital Forensics, LLC, and he's going to be talking to us today about child pornography cases. And I think that it will be very, very interesting. Let me use some of my sound effects and bring in Stephen Alexander. Welcome, Stephen.
Hi.
So you are the president and founder of, I see behind you, Trace Digital Forensics, LLC. Is that correct?
That's correct.
Or is that just somebody else's sign that maybe you stole?
Oh yeah, I stole that down the street.
So tell us what Trace Digital Forensics is.
So I started Trace Digital Forensics about 5 years ago, and we're a digital forensics firm. So I do computer and mobile forensics and consult with attorneys on civil and criminal cases that involve digital evidence, and also do some e-discovery and work with some other clients that aren't legal, like county governments and things like that.
So just all digital evidence, cell phones, computers, what in this day and age, what is digital evidence in 2020?
So cell phones, or anything we can pull off a cell phone, anything we can pull off a computer, other storage device, hard drives, flash cards, thumb drives, that sort of thing. So pretty general computer forensics firm, a mobile forensics firm. The only thing I don't do right now is I don't do vehicles and drones.
Okay, so like the black boxes in vehicles?
Yeah, I don't do that right now.
Okay. Are you looking into doing that?
No, I stay pretty busy with the stuff I've already got, and you know, I'm an independent shop. My goal is to be independent and work directly with attorneys. I don't want to be a larger firm necessarily, and I can't be an expert in everything. So I feel like I'm doing pretty good with the things that I do now, and I'm just going to keep working on that.
Okay, well that sounds good. That sounds good. And you're out of Bakersfield, California?
California.
And how are you guys doing with the shelter in place and the lockdowns and everything?
It's been interesting. So, you know, I'm working completely from home at this point. Kids are schooling at home, trying not to go out. Shopping's getting a little easier. You know, first week or so, we go out and, you know, the shelves would be empty. There's no meat, there's no bread, because everybody's sort of panicked and stocking up. And, you know, now when we go out, there may be some things that are they're out of because maybe they haven't gotten a shipment in a few days or whatever. But the shelves are starting to refill, and we're just kind of getting used to not being out very much.
Well, and I wish that it wasn't going to be a while. Unfortunately, I think it could be a while. I don't know. You know, it's a virus. A virus doesn't have a date on it, right? You know?
Yeah, I'm expecting it to go on for a while. They've already said that the schools are going to stay closed through the end of the year, so they're not going to reopen until August. So, you know, my kids are communicating with their teachers online and doing their classes that way. But they're going to be home for the next 4 months.
Well, and I think that hopefully getting these CLEs out, or QLEs, like I like to call them, quarantine legal education. Hopefully, we're helping our viewers get those credit hours needed. And I think with that being said, I'll let you take it over, and you're going to give us a presentation on child pornography, digital forensics.
So you should be able to see that now?
Absolutely, that's great. Thank you.
All right, excellent. So like you said, I'm going to be talking about digital evidence in child pornography cases. To start with, I give you a little background about the business. I've been doing trace digital forensics for 5 years. I've been doing technology for over 20 years, and I started doing forensics when I was working as an IT director, handling, internal investigations, HR-related things. And, I got certified with NCASE, and I wanted to start doing that on my own. So 5 years ago, I branched out, and I still work full-time as an IT security director, and I do all this on top of that. I have a master's degree in computer science, master's degree in information security, specializing in digital forensics, and I'm certified to do forensics with NCASE and with Magna Axiom. I also have a couple of security certifications, the CISSP, which is a Certified Information Systems Security Professional, and the GSLC, which is the SANS Security Leadership Certification. So the first thing I want to get into is a little bit about how to work with a digital forensics consultant. And the reason I wanted to bring this up is that sometimes the process of working with someone in digital forensics is a little different than other specialties. And part of the reason for that is that the investigation in digital forensics is a little more open-ended, and we're not always looking for a black and white answer like in some other fields. When you're doing a DNA test, you're looking for basically it matches or it doesn't match. Right, and it's not really necessary for them to know a whole lot more about the case than that.
We like to think there's a lot more to that.
There's a lot to the science, not underestimated. There's a lot to the science.
I'm just giving you a hard time.
That work can be sent to a lab, and they don't necessarily need to know a lot about the legal portion of the case, or at least that's my understanding of it. The science is beyond me. I don't do DNA testing. I can't test drugs to tell you if it's crack cocaine in a vial or anything like that. Just recognizing that some of that lab work is a little more removed from the actual case. And when it comes to digital forensics, a lot of what I do is looking at the discovery, search warrant applications, forensic reports, investigators' notes, in some cases testimony if we're already past that, and trying to figure out, one, what happened in the case, how the investigators did their investigation, if they followed proper procedures, and really understand the full context. And as I said, it's a little more open-ended than some of the other specialties where, at least in some cases, they're looking for fairly concrete answers about things. And in digital forensics, often it's about what are the possibilities, what sorts of things would explain this. And so when I start out working with an attorney, obviously do an initial consultation. And for me, that's really the first chance to learn about the case and find out what the actual goals are here. And in some cases, the attorneys do want something fairly standard. It's like, look, I need all the text messages off my client's phone where they texted with this number, right? They're not asking me for anything else. They just want to be able to review those. They want someone independent to pull those out, and that's fine. But there's a lot of other cases where it's a little more complex than that, and they're wanting to know, did my client do this? Did they do that? Maybe we know the client downloaded, say, child pornography. It's an open question whether they shared it, and there may be questions about the dates of certain files and what the timeline was, and they're looking for someone to help them figure that out. And so for me, I can offer a lot of advice to attorneys, and this is true of any good digital forensics consultant, but it's important that we understand a little bit about the case in order to be able to do that. And so, after the initial consultation, I'll move on to, reviewing discovery, reviewing forensic reports, and then usually we can talk and figure out, what our strategy is, where we want to go from there, what the next steps are, and then have some choices. Do you want to have me do a full forensic examination, which isn't always the best course of action, right? It may be a case where, the defendant may or may not be guilty, but the best strategy is really to attack the investigation that's been done so far, because they've missed steps and they've not followed up on things and they misstated things, and not necessarily a good idea to have me go through and do a thorough examination and do the police's job for them when you've got a better plan of attack for your case is to discredit that. And so the first child pornography case I worked on, actually, I didn't do any investigation at all. It was totally focused on consulting for cross-examination. The defendant had admitted to downloading certain things. He denied that he knowingly shared them, and so there were questions about the activity on his computer, and the law enforcement examiner was saying, look, there's only one way this could have possibly happened. And I worked with the attorney. There were actually, I think, 5 or 6 different possibilities that we could come up with for how, these events had happened on his computer. And the attorney picked the one that he thought was the easiest to explain and would help in his case. And this is a bench trial, and so he gets the law enforcement examiner back on the stand, and we had a play-by-play, click-by-click, how this could happen that was different than what he had said was the only possibility. And so the attorney walked him through that on the stand, and he said, could it have happened that way? He said, yeah. And we got an acquittal out of that, right? And that was without doing any examination at all. Consulted with the attorney, did experiments, but never examined the hard drives in that case. And so I think it's really important to discuss these things. And I like to know everything about the case, right? And there may be some cases where there's stuff that is, totally irrelevant, but it's important for me to know what the client's charged with, what they already admitted to, because I'm looking at possibilities. And if your client's already admitted, hey, I did this, then he's already eliminating possibilities, right? So when I'm trying to consult with you and give you some advice about how you can proceed on the case, directed by the technical parameters, I need to know if those possibilities are already not possible. It's also important to know how the complaint came about. Where did this case come from, and what evidence is out there? Do they have his phone? Do they have his computer? Do they have external hard drives? What sort of stuff have they already identified? What police reports, warrant requests, forensic reports and stuff you already have? Are there reports from the National Center for Missing and Exploited Children? Because I want to look at all of those, because they all play into each other. And so if my focus is too narrow, I'm not going to fully understand what I'm looking at, and then I can't give you good advice. So, and here's an example, and these are just hypotheticals. So child pornography cases, let's say there's a case where police believe that child pornography was downloaded from the defendant's residence, from his IP address. They already talked to the internet service provider, that sort of thing. But he lives there with 3 roommates. Maybe they share a computer. There's a lot of possibilities there. Even if child pornography is present, the defendant may not be the responsible party. And so it's going to be very important to figure out the timeline on that, who else used the computer and when. And actually, there was a federal case I read about not that long ago where there were several men living together as roommates, and one of them was charged with downloading child pornography. And what eventually came out of the case was that the roommate had used his computer because he had trouble installing the peer-to-peer program on his own machine. So he waited for the defendant to go to work and then used his computer to download this stuff. And that wasn't just a hypothetical suggestion. The examiner in that case was able to actually prove that that was the sequence of events, to the point that they dropped the charges against the defendant and charged the other roommate. Now, looking at a different case, if we have a defendant who was accused by a relative of touching her inappropriately and taking pictures of her, then anything that is found on his computer, any sort of child pornography, is going to confirm that, right? There aren't going to be other possibilities. And so it's going to be a more black and white situation if any of that material is found. So first up, let's talk about next up, let's talk about the complaints. So there's different ways that a child pornography investigation can be started. And we're going to focus on the first two that are listed here, which is complaints that are submitted through the National Center for Missing and Exploited Children, and investigations that are started by law enforcement based on the use of file sharing or peer-to-peer programs. There are also online stings. The online stings tend not to focus on the child pornography itself, but focus on people, soliciting minors online, and then the child pornography investigation may branch off from that. And there may be other cases where they're looking at something unrelated, say it's a drug case, and they find pictures on the phone. Or it may be incident to a case where they're investigating, child molestation, something like that. But the other facts of those cases all impact how you're going to proceed on the investigation and what your strategy is going to be. So I'm going to focus on the first two, and then we're going to talk about some things that apply to these cases a little more generally. So the National Center for Missing and Exploited Children is a private nonprofit organization established by Congress, funded by Congress. Its mission is to prevent child abduction and sexual exploitation of children. And they operate the cyber tip line, which is where a lot of child pornography investigations start. The cyber tip line is a clearinghouse for primarily tech companies to report people who are uploading or sharing child pornography on their sites. And despite this technically being a private, it's not a government organization, it's congressionally funded and essentially has a law enforcement mission in taking in those cases and referring them to the appropriate law enforcement agencies. The electronic service providers, and that's the language they use in the law, but we're talking about tech companies, Facebook, Tumblr, Google, Microsoft, Twitter, Snapchat, any service provider where people will be posting and sharing content online.
What about the dark web?
The dark web would typically not come up in this because in the dark web, people are using generally Tor, it's an anonymization service, to hide the location of their websites and to have websites that are not easily accessible to other people. They're not going to show up on a regular search engine. You've got to be on that service to find it. And those players are generally not going to be reporting.
Like 4chan?
Well, 4chan is still a public service, and so they could still report things. But the dark web can be used to set up sites that are harder to find. And so they're trying to maintain some privacy there, and especially if they're setting up child pornography sites there, they're going to be probably hosted offline. They're hidden behind Tor. They're trying to not let people know where they are. And so you're generally not going to get NCMEC reports from those. So you may have other investigations that find them, but they're not going to be turning in their users. With other tech companies, despite, and there have been some articles recently complaining that the tech companies don't do enough to report their users, and some report more than others. But the fact is that NCMEC received over 18 million reports in 2018 for over 45 million images and videos, which says that tech companies are actually reporting quite a bit. And I would guess that was probably up for 2019, and it's probably going to be up again for 2020.
Is there one tech company over another that reports more?
I couldn't say offhand which ones report the most. I've seen complaints for a few different tech companies. I know Apple gets called out for not doing a lot of reporting, but most of the material that's being uploaded to Apple's site isn't being shared the way it is with, say, Facebook or Twitter or whatever. And so the tech companies are reporting a lot. Maybe they're not reporting enough. My understanding is they're already reporting more than law enforcement agencies are able to actually investigate, because I'm pretty sure there weren't 18.4 million investigations of child pornography in 2018, even though there were over 18.4 million reports. And the companies are not required to report. There's some new legislation in the works that would essentially force them to scan for and report this material. But what a lot of the companies do is they use software provided by Microsoft, which was donated to NCMEC, to scan for images of child pornography so they can detect them automatically and report them. And when they do report or identify this material, they're required to preserve it for 90 days so that law enforcement can request additional information. And that's going to be an important point as we move through this. So the NCMEC report is going to include some basic information about the users they report, their username, their IP address, any other contact information they might have for the user, which is going to vary. It's going to vary by the site, right? If it's a site where all they require is an email address and nothing else, they may not have a lot of information. If they require you to verify their cell phone number, then they're going to share that. And the report will include examples, not necessarily all of the offending information, but the actual images of child pornography that are detected are going to be attached to the report. They're not going to be in the body of the report, which is important to know because the report itself is not going to be subject to the Walsh Act. It can be shared with the defense attorney and their experts. The attachments, however, may need to be viewed at a law enforcement facility. So let's walk through the structure of the report. And I've got some screenshots on here that will show you some redacted reports. So first up, and I realize some of this is pretty basic, you're going to have a cover page. The cover page is going to have the cyber tip line report number on it. And it's important to make note of that because elsewhere in the report, they will reference other cyber tip line reports that refer to the same person or may refer to the same person. And so you're going to want to cross-reference your reports and make sure that you have all of the reports that are referenced from the reports that you have. So if you have 3 reports and you look through them, and between those 3, they're referencing 5 different cyber tip line numbers, then you don't have everything. And there's going to be a little executive summary on the front, and the important thing that you're going to see there is the total number of uploaded files. And then the next page, they're going to give you a table of contents that shows you what else is in the report. It's pretty self-explanatory. And then the first section in the body of the report is going to be they call it reported information, and this is information that's reported by the electronic service provider or online service provider. And they start out with their contact information, and they give a contact point for law enforcement to reach out to them. And then they have a company information section, and the company information section, we'll look at an example next up, is not information about the company. It's not, the kind of information they'd share with investors. It's things that are relevant to how the company reports and responds to requests for more information regarding these cases. So like this is an example from Google, and I'm not going to read the whole thing, but like there's an important section here at the bottom where it says, with respect to this, report, for each image it'll ask, was this reviewed by the company? If they say yes, it means they reviewed it roughly when they reported it. If it says no, it actually still means they reviewed the image. It just means that it's an image that they previously identified as child pornography, and so they don't have their analyst or tech person who's doing the reporting review the image again. And then the next section that we're going to see, our next part of Section A is going to be the incident information, which is a really brief summary of what this report is about. So here's an example. They don't distinguish what type of child pornography offense this is. They just say, hey, there's images we've detected at a certain time. And in this case, they clarify that the time is when they're reporting it, not necessarily when it was uploaded. They tell you which particular web page on their service was the offending site. And this one's from Tumblr, and Tumblr allows people to set up blogs, so it'll be something.tumblr.com. And so they're telling you what the address was for that. Then they're going to give us the information that they have about the user or person being reported. And basically, they're going to give you everything they have. And for the IP addresses, sometimes they'll give many of them. and they'll tell you what the dates are associated with them, because they may have had the user may have had different addresses at different times when they connected. And then they'll give some additional contextual information, which may include what look like log entries, they're really not. So we'll jump forward. And this example is still from Tumblr. So we can see up here, we got basic contact information that I've redacted out. And then they clarify that the IP address they're giving is the last IP address that was used by this user. And then below, they tell you they've taken the blog down so that it's not accessible. And they clarify again that there are other materials that they have that they're going to keep for 90 days, and they will turn them over if law enforcement requests them. And in this particular case, law enforcement did not request the other materials, and those were actually important to the case, which we'll get into a little more later. So it's really important to pay attention to these various notes that the service providers are putting into these reports, because they will give you some insight into what their process is, what information they have or don't have, and what they're willing to share. And then below, they have several pages of activity from this user that's part of what they're reporting. And they're saying basically we're reporting these different posts that this person made on these dates from these addresses. And then for each file that was uploaded, there will be an uploaded file information section where they'll give a little bit of information about the file. And in this case, and this one was still one of the Tumblr ones, they give almost no information, right? They give you the file name and that's it. Whereas this example, which I think is from Google, they tell you the file name once it was uploaded, the file name before it was uploaded, which is the same thing in this case. But that's important to have because some of these sites rename the files when you upload them. And for law enforcement going in and doing their investigation, they want to be able to match those images, and having the file name helps with that. It also helps to have this MD5 value, which gives you the hash or digital fingerprint of this file, and it can be used to uniquely identify that file so they can search the hard drives for it. And then it tells you whether or not they viewed it, and we're still talking about the tech company, not NCMEC, and it tells you whether they looked at the metadata inside of it, and here they didn't specify that. And then it asks, were the contents publicly available? And that's really important, and in this case, we have that information that was not publicly available, which is very helpful because if your client is charged with distribution, you're going to want to argue about whether or not they actually distributed. And in this case, the information, the files were uploaded to their Google account or whichever account this was, but they didn't share them with anybody else, at least as evidenced by this. Whereas with the Tumblr example I looked at previously, there was actually a question as to whether the files were publicly available because Tumblr allows people to set up sites or blogs that are public or that are private and are password protected. So the question then is, what are the rules in that jurisdiction where the defendant was about distribution or transmission of child pornography? And did they meet that by uploading that to this Tumblr site? And again, we're missing some of the information because law enforcement didn't request it. And then the last thing we see here.
Well, let me interrupt you really quickly. On that, where it says were entire contents of upload file publicly available, you kind of mentioned it, but if I know, like on Facebook, right? I have a college group of mine that is available to everybody that went to school with me back 1,000 years ago, and it's a private group, right? But it's still kind of public, right? It's not set for a public setting, so everybody could look at it. Not that we have anything to hide on a college chat room, but do you see what I'm saying? I mean, it's a private group.
So as far as I know, there is no standard for how they answer this question. Obviously, from a perspective of are they distributing child pornography, if they shared it with anybody, right? If someone's got a 2-person Facebook group where they share with one other person and they posted these images so the other person can see them, it has been shared. But then I don't know if Facebook would consider that publicly available or not. And the only way to get an answer from that, rather than make an assumption, will be to ask Facebook.
So when it says no, we're not really sure if it's no.
Well, I mean, the defense attorneys would probably argue no is no, because that's helpful to their case, right? And the prosecutors the burden would be on them, I would think, to go and get that information and prove that, you know, this maybe wasn't publicly available, but it was shared with other users. But having the no from the defense perspective would probably be helpful, because at least to this point, we're saying that it wasn't shared.
Okay.
And then the last thing we're going to see here is the image categorization. And not all of these reports will have that, but this one did. And the explanation for how the images is categorized, and there is a standard for this developed by the tech companies, is in the next section of the report, but we're going to jump ahead and look at what that is. The pictures are categorized as A1, A2, B1, or B2. And A or B means either prepubescent or pubescent minor. And 1 means sexual act or exhibition. And so what they're doing is they're making a judgment call as to how old the person in the picture is. So for younger children, they're going to be A's. And then they're making a judgment as to whether this involves an actual sexual act, which generally is going to be any sort of, you know, touching between the parties, genital contact or stimulated genital contact, or oral to genital, or whatever. And then the exhibition is going to be more just posing and modeling nude and that sort of thing, and exhibiting genitals. And this is important to know what you're working with, because each jurisdiction has different sentencing criteria for child pornography. And so the age of the kids in the pictures may affect the sentence or the charge the defendant gets, and whether or not there's penetration or other certain acts like bestiality or whatever may impact what sorts of charges and sentence the defendant is facing. So this will give you a good idea, without even looking at the pictures, what they're asserting is actually in them. So moving forward, sections B and C are populated by NCMEC. They are not from the tech company that's doing the reporting. And section B is automated. It's information that NCMEC's system is able to automatically add to the report. And then section C is information that one of their analysts adds manually. And the biggest thing in section B is the geolocation information. And this is from a real report, and I partially redacted it just to give some sense of how these are filled in. But you're going to have an IP address that tells you, or they should have all the IP addresses from the report in here. And they just do a geolocation lookup to find out where these are. And it's important to understand that this geolocation is not super accurate. It is not like a GPS location. This is just looking up the IP address, finding out what service provider owns it, and looking up in one of the online databases that's available, or maybe a private database, to find out generally where this address is. And so it says, you know, here, this is in Studio City in Los Angeles. I mean, it very well could be in Hollywood, but it's probably not in Houston, unless they made a mistake in the database. And the purpose of this is just to help them understand what law enforcement agency this needs to be handed off to. It is not to locate the suspect at this point. They want to figure out who owned the address. Like, this address is owned by Spectrum, so they're going to give a subpoena to Spectrum and say, hey, at this date and time, this person using the address 47.25. whatever, we want to know who the subscriber was, right? And they're going to come back and say, okay, well, you know, the subscriber was Bob. You know, here's the address we have on record for him, and then they can continue with their investigation and get a search warrant and that sort of thing. And I think I actually left a slide out here. So I said that section C is, on this side, I said this is the additional information they add manually. And the big thing that you're going to see there is they're going to reference other cyber tip line reports. And they cross-reference the reports if there's a matching username, screen name, email address, IP address, anything that would indicate that it's the same person. And it's not necessarily, right? The IP address being the same, I mean, Spectrum or AT&T or Comcast, they have a lot of users. The addresses change over time. So the address you're using today could be the one I was using yesterday. And so when they're cross-referencing these, it's not 100% that this is all the same person. But you are going to want to look at that and see what other cyber tip line reports are referenced and make sure that you have all of them.
Do you want to kind of explain, maybe it's just me, but maybe there are other people out there that don't realize that back in the day when we had an IP address, it was our IP address. And now, because there are so many that they're just kind of rented for a time, if you can look at it that way.
Right. So how permanent your address is depends on what kind of service you're using. For instance, if you have a business class connection from your ISP, it's possible that they will give you an IP address that will be your address for as long as you're using the service. But in most cases, those addresses are going to get rotated around. So in some cases, if you disconnect, like you unplug your modem and plug it back in, whether it's cable or DSL, in some cases you may get a new address the next time you connect. In other cases, the address is going to be leased to you for some period of time. And as long as you're continually connected, you might be able to keep using the same address for months on end. But there's no guarantee of that. And this is another thing that comes up. When law enforcement send the subpoenas to, say, AT&T, and they say, hey, I want to know who's using this address, it's really important that they include the date information and that you look for that in the search warrant applications, because those addresses do change around, even though they may be semi-permanent in some cases, as long as you stay connected, they do change. And so if they're requesting for a particular address and they don't provide a date, more than likely the provider, if they're able to answer the request at all, is only going to tell them who's using that address now. And the person who's using that address now may not be the person who was using it when the NCMEC report was made or other complaint was made that kicked off this investigation. So those addresses are definitely not static. And the other thing to be aware of is that they are shared between devices. So sometimes you'll see things saying that an IP address uniquely identifies a particular device, and that is not true. The IP address can identify a single device, or it can identify a whole group of devices. So on my home network, for instance, I have a cable modem, and it's assigned an IP address. And behind that cable modem, we have our smart TV and the Blu-ray player and, you know, our cell phones and our laptops. And, you know, we've got like a dozen different devices on our home network. So when you're looking at that IP address, you don't know which device is actually responsible, because they all share the address that the cable modem has. And if we have guests over and they use our Wi-Fi, then they are also sharing that address. So it does not uniquely identify a person, and it can change over time.
What about a router in front of that?
Same concept. I've got a router and cable modem together. So it's actually the router that's helping to have everyone share that same address, because the cable modem, at least the one we have, only allows one person to be connected to it. So it allows the router to connect, and the router is actually the device that hides everyone. You know, and the other thing we'll come up with that is, you know, I mentioned, you know, people within our household or guests within our household, but for people that have open Wi-Fi connections, you also have the issue that, like, if I'm in an apartment building and I have open Wi-Fi, all of my neighbors could be using my internet connection. And so when law enforcement are doing their investigation, you know, they contact the ISP and they come up with my name and they're like, okay, this is our guy. And if I'm sharing it with the whole, you know, the whole apartment building, then it could be anybody.
Right, and it's important, like you said, to note if you unplug it, if the power goes out, it can change.
Yeah, and when law enforcement are being thorough with their investigations, often they will go out and park outside the home and scan for open Wi-Fi networks to see if they're all password protected or not. And that way they can include that information in the search warrant. It's like, yeah, we stood outside Bob's house and, I scanned for open Wi-Fi, and all the Wi-Fi networks that were in range required a password. So we think this is really, within his house and not, some other party. Oh, and then, so jumping back to the NCMEC reports, and we're almost done getting to the structure, the last thing you're going to see on there is, again, pretty simple, and it tells you the law enforcement contact information for the agency that they referred the report to. And often this will be an ICAC task force and not the local department. Because again, when they're doing these investigations and they're trying to geolocate an IP address, they may know that a certain address belongs to Spectrum in the Bakersfield area, right? But it may not actually be in Bakersfield. It may be in another town that's outside, the Bakersfield city limits or something like that. So if they automatically refer it to, the Bakersfield Police Department, that may not actually be the correct agency to take that on. And so often they'll give it to an ICAC task force, and they can do some additional follow-up before determining which individual agency needs to take it over. So there are some legal issues with the cyber tip line reports. And the biggest thing is that the cyber tip line reports are sometimes treated as evidence. And I'm not a lawyer, so some of our attorneys that are listening are probably familiar with some of the cases I'm going to talk about. If I have gotten any of these dramatically wrong, please shoot me an email and let me know. I'm an interested party, but I am not an attorney, and so don't depend on my legal analysis here. But my understanding of the Melendez-Diaz case is that the introduction of forensic evidence in the form of lab reports was determined to be testimonial in nature, which means you can't just submit the lab report and not have someone testify as to how that work was done and what it means and that sort of thing. Because they're submitting a test, whether it's a DNA test or a drug test or whatever, that is used to establish some fact that's relevant to the case. And so the defendant has a right under the Confrontation Clause to challenge the person that's making that statement. You can't just submit that report and say, hey, deal with it.
But are
so
these being submitted as lab reports or as business records?
That's the next slide. So the question then is a cyber tip line report testimonial, or does it fall under the business records exception? And that's still somewhat of an open question. But there was a case, US v. Cameron, where the court determined that the primary purpose of this report is to establish or prove facts that are relevant to criminal prosecution, and it's testimonial in nature. It doesn't fall under the business records exception. And then there was another case, and I'm citing this one here because I think it might be useful to look it up. It was an unpublished case, but the reasoning in that case may still be valuable. It was in a different circuit, and they also determined that these cyber tip line reports are testimonial in nature. And what I think is really important about this, and I'm thinking about it from the technical perspective, these are not, to my mind, business records. Business records are things that are generated automatically in the course of the business. So certain log files off a server, say like a Microsoft Windows server running the IIS web server, those logs are generated automatically. Microsoft controlled how those were generated, and there's no involvement in deciding what to report. Those logs aren't generated for the purpose of detecting crime or anything like that. And so that's the kind of thing that might be more likely to be considered a business record. With the cyber tip line reports, they're generally generated because they've used some software to detect that there might be child pornography. And then whether it's semi-automated or fully automated, they're collecting information about the user. They're collecting information about these logs. They're often summarizing the logs. They're correlating them with other data sources, and then they're putting together this report to send to NCMEC. And it is essentially a criminal complaint. I mean, they are complaining that, hey, this crime has occurred, and here's all the information that we've collected on it. But there's lots of places where that collection could go wrong, and it really doesn't make sense to treat it as a business record in terms of it being reliable and automated and that sort of thing. Because if they correlate the wrong things together, they can make a mistake. And in one of the cases I looked at, a number of uploads were reported under a certain user account, and they included what looked like log entries in the NCMEC report, but it's not the full log entry, it's just certain parts of it. They've summarized that data and collected what were supposedly uploads under this account, which were then being used to charge the defendant. But the problem with those is, there's information left out, which would have been helpful. And then the log entries had IP addresses that were in other parts of the world. There were some that were in the defendant's jurisdiction, but then there were other addresses that were geolocated to other states and other countries. And as far as we were aware, this person had never traveled outside the country. And so that's the kind of thing that I see that tells me, man, someone may have made a mistake when they did this query. They may have grabbed some data that was relevant with some other data that wasn't relevant. And from a technical perspective, I would really like to see these things be able to be challenged and to see the original logs coming into court instead of the NCMEC reports. Because, and again, I'm thinking technical instead of legal, but these things do deserve to be challenged. Doesn't mean they're always wrong, but there are opportunities for them to be wrong.
Is that something that you're asking for in discovery?
Yes, I'm always advising the attorneys to ask for all of the information that went into producing the cyber tip line report, and not to just take the cyber tip line report as fact. Especially if the other information that they find later doesn't seem to back up the initial report. And there may be some cases where it's not worth going after these because, it generated the initial criminal complaint, and, they grab the guy's computer and, he's got all the materials are on there, and maybe he admits that he downloaded them and not that he shared them. And, the attorney may determine that it's not worth it to go back and get these, that they're not going to find anything that undermines the case. And so they can definitely make that call. But in general, I would want to have the information. And it's also important just to understand that information may be valuable, because often the attorney doesn't have a choice, right? Law enforcement didn't collect the information within 90 days. It's no longer there. It may have been exculpatory, and they didn't grab it. And so there may be some legal arguments to be made that that unduly prejudice the defendant. And I'm not the lawyer, so I'll let them handle that. But they need to understand that there are things missing because of a law enforcement oversight that could have helped their client.
So would it be beneficial for if a lawyer gets involved in one of these cases, is it beneficial that one of the first things they do is to go out and get the information that sometimes is not received by the police department, so you don't miss that 90-day window? And do you have a list of what they need to jump in and get right away?
If they can get the information, it's probably beneficial. And what they're going to request is going to depend on the service provider and on what's in the cyber tip line report. But in many cases, it's going to require a warrant, and so it really does have to be law enforcement that goes out and gets it.
Well, a subpoena would be able to, if the defense attorney was able to get a subpoena for discovery.
Some of the tech companies won't answer the subpoenas, so there's a lot of legal wrangling to be had there, and that gets beyond my expertise for sure. But my understanding is that some of the tech companies, for certain types of information, they'll only respond to a warrant.
Okay, but if the lawyer is able to get a subpoena for it, and they go through the legal department and they can get it, is there a list of certain things that you suggest that they go after within that 90-day period so they don't miss anything?
It's going to depend on what is in the cyber tip line report, and it's going to depend on the particular service provider in terms of what they have. And there is example warrant language or subpoena language out there for different service providers, and some of them will provide that and say, hey, these are the kinds of things that we have that you can request. And so you're going to request everything that they have, basically. Look up this provider, talk to other attorneys if you have to, find out what language is available for that provider, request everything that they have. And then, you know, there may be other clues in the NCMEC report that tell you what sorts of information you're going to need. But it's not cookie cutter. There's no language I could give you that would apply to all of the providers at all.
Okay.
So let's look at some examples of the technical issues that come up with these cyber tip line reports. And I use this Tumblr example for a lot of the slides here. So it shows here, and I've anonymized these a little bit so I don't have to black anything out. So you've got these post IDs, and there's no information about what a post is, but it's implied that it means a file upload. It gives you an IP address and a date. But there's a lot of stuff that this doesn't tell you. Tumblr's website, it allows you to upload files. It also allows you to reblog or repost a file. And that's similar to sharing a post on Facebook. You posted something and I shared it onto my page, or on Twitter, retweeting somebody. And there's no information provided as to whether these posts include repostings or if these are all original posts. You'll notice that one of the IP addresses here is 0.0.0.0. The other one is an address I made up, but 0.0, that's not a real address. And that was actually in the report. So on what basis, like, I don't know what that means. I don't know how they associated that with the defendant, or how they would prove that it came from the same place when they didn't include a real address in that. So I have no idea what that means. And because they don't have the other information that would be typically stored by a website or web application, there are things missing. So it doesn't tell you what the original file name was, which would be useful when you're trying to match the activity back to the defendant's devices. And it also doesn't tell you what web browser they were using. And most web servers will capture that information. So they'll tell you that the client was using Safari, or they were using Firefox, or they were using Chrome, or they were using Internet Explorer, or they were using Edge. And they may even be able to tell you if it was an Android device or an iDevice or a Windows device. And if it's using the tech company's own mobile application, they may be able to tell you that information. And none of that is included in here. And it's all relevant for trying to show whether it was the defendant or not, because if we know that the data was all uploaded from an iPhone and the defendant doesn't have an iPhone, that would indicate that the defendant's not responsible. So I already said that. Keep going. The other thing that wasn't included with this, and this is where the law enforcement did not follow up to subpoena the rest of the information. I said that in this case we had seen IP addresses that were not just from the defendant's area, but also from other states, other countries. And in addition to the pictures that were being posted, they can be posted with captions. People can go and post comments afterwards. And we didn't have any of that information. And especially where some of the posts were coming from other countries, it would have been nice to get those captions, because if they're being captioned not in English and our defendant only speaks English, that would again be an indication that there are other people involved here, and that at least some of this activity the defendant is not responsible for. And they also didn't say whether these were uploaded to a public or a private site, or whether they were ever downloaded, which is all relevant to whether the defendant was distributing child pornography rather than just storing it for himself. So this kind of goes, this first part goes to what I said before. I consider the cyber tip line report to be the start of an investigation, essentially a criminal complaint. And it really doesn't prove the case. There's a lot of questions about the information that's in the reports, and it's important to request that information or challenge the prosecution if they don't have that and didn't request it in time, because that information may be exculpatory. And since it's often only available for 90 days, if they don't request it, it may not be available at all. I already said the geolocation is only a rough indicator. I've said that it could be incorrect. And then the last point, NCMEC may or may not have reviewed the images to confirm that they're child pornography. And one of the things that comes up in all child pornography cases is that all of the images that are marked by law enforcement as being child pornography may not be. It's probably unusual that none of them are, but it's fairly typical that there are other things mixed in there, and it's important that those images are reviewed at some point, whether it's by your forensic examiner, by the attorney, or by someone else. So following up from that, the cyber tip line reports will identify a particular IP address as being responsible for one or more of the uploads to this account. And the investigators will typically follow up and issue a subpoena to find out who that address belonged to. And what I mean is they'll issue a subpoena to AT&T or Verizon or Spectrum or whoever and say who is the subscriber that this address was leased to at this time. And again, it's important that they specify a date and time because, as you pointed out earlier, it changes. So if they're only requesting for that IP address and they're not providing a time frame, then the internet service provider is only going to be able to say who used it last, which may not at all be the person who was identified in the report. And then they can request a warrant to search the service location. And again, when they're being thorough, they will follow up and verify that they didn't have open Wi-Fi. They'll try to determine who lived in the house and that sort of thing. In some cases, they may not. They may jump in without providing all that information. So problems with attribution based on IP address. We already talked about the fact the addresses change over time. They may be shared by several people. Some other issues that can come up, theft of service. With cable internet at least, it is possible to clone someone else's cable modem and get service under their account. And the cable service providers have steps that they can take to prevent that. So it's not necessarily a simple matter to do that, but it is something that happens. And that can be one reason why the cable internet service provider might identify a particular person as being the subscriber, and they may not actually be the person who was leasing that address. And the internet service provider could also make a mistake in billing records, or they can make a mistake if they're having to correlate records from multiple sources. And I've had that happen before on a business network where we were misattributing activity, and it wasn't a child pornography case. It was actually we were doing some HR investigations on people who were browsing adult pornography sites when they were supposed to be working. And what we determined, because we identified a particular employee as being responsible, and then realized that she was currently online at like 5 different locations within the business. And we had a guest wireless network and determined that what was happening is we were correctly identifying staff when they got on the wireless network, but we allowed guests to use it. And since we couldn't identify them, it would give credit to whichever staff member used that address last. And so you could have a staff member getting credit for someone else's internet activity. And we determined that before we moved further in the investigation. But, we had initially misattributed who was responsible for that activity and had to make corrections in how our network was set up to prevent that. And so that's probably more likely when you're looking at a business location where they've got Wi-Fi access and maybe guest and staff networks and things like that, where it's a little more complex. But even within an ISP, they could definitely, it is possible at least for them to make a mistake and identify the wrong customer. May not be common, so I'm not trying to pretend that this is, it's not junk science or anything like that. It's just that there is room for mistakes to be made. The other thing that can come up, and we talked earlier about the dark web and the Tor service. Tor is an anonymization service that allows you to hide your identity when you're browsing online or hide the location of a website. And it has good and bad purposes. It was actually, if I'm recalling correctly, it was invented by the U.S. Navy, or a research project that was funded by the U.S. Navy. And, it is used by people in other countries where they've got, governments that, try to crush political dissent and things like that. And so there's some really valuable purposes in having this available, but then people also use it when they're online trying to do illegal things like download child pornography. And when you're using Tor, your traffic routes through other people's devices. So if I get online with Tor, my traffic is going to bounce through, say, 10 other people's computers. And if you are managing a Tor exit node, you've said you want to participate in the network, it's possible that your computer will be the last computer that my traffic comes out of before it goes to a given website. And so if somebody is using Tor and they do bad things, then it could be the person running the exit node who gets credit for that and ends up getting investigated. And it is possible for law enforcement to go look up what the exit nodes are to try and rule people out. But it's another explanation for why they might identify a particular person as being the bad actor responsible for some online activity when it's not actually them. So, we talked probably too much about IP addresses and why they're not 100% accurate. So when the law enforcement is doing the investigation, if they're being thorough, they should be trying to tie the activity back to the defendant's devices and try to match the activity that they can recreate from that device with the activity that they were seeing online, so they can prove that it was the same device and ultimately the same person. And so with peer-to-peer file sharing, one of the things they can look at is, was the appropriate peer-to-peer software even installed on the device, or had it ever been installed on the device? Maybe it was uninstalled recently, but it used to be on there. If there is peer-to-peer software, because lots of people use peer-to-peer software and they may use it to download music or download software distributions or whatever, it's not all bad stuff. Was that program being used to share the offending material, to search for similar material? Did they actually share other, child pornography images or whatever with it? And did they have child pornography on the computer? And did they have some of the same child pornography that law enforcement observed being uploaded on that computer, so they can show that, yeah, this is actually definitely or likely the source of the activity that we were investigating?
Now, there used to be software that was like Napster, right? That was
Right.
a peer-to-peer,
Yes.
and then there was one, an ICA, or I may have the letters wrong, but what are some of the peer-to-peer software?
BitTorrent, Nutella, Aries, and there's other smaller ones, and some of them use the same underlying networks. So yeah.
Are you seeing some more than others utilized for this?
It varies. The last one that I saw was using Aries, so it may vary. I see more of the NCMEC cases than I do peer-to-peer.
Okay. I was just wondering.
Yeah. And so when you're matching activity to a defendant's device with the website, and I'm trying to look at this from the law enforcement perspective, what does a thorough investigation look like? Because these are the things that you should be looking at as a defense attorney. Did they do these things? Did they try to make, did they try to match this stuff up, or did they just jump to conclusions? And so if I'm matching from the defendant's device to a website, again, we want to know, was the device that was seized the device that was used to access the site in question? Did they have account credentials stored on there? Is it in their internet history? If it's a mobile device, did they have the app installed? If a certain email account was used to register on the site that did the reporting, did the defendant use that same email account? Was the information for that account on the device? And again, was the offending material on the device? And I had a case a while back where I want to say 150 or 200 images have been uploaded on different days, and they only recovered one device from the defendant, and he had a small number of the same images on his device, but he didn't have most of them. And that and some other things made me doubt that he was actually responsible for most of the activity, although he might have been responsible for some of the activity. And that was one of those situations where they may have credited him with uploads that he wasn't actually responsible for, where it may have been multiple people sharing on the site. And there's different ways they can follow up. So I made up an email address. Someone probably actually uses that. But if material is uploaded to a site and it's connected to an email address, it may be important for them to subpoena the email address to find out if this person was actually using it and prove that they were actually the one in control of that account. And that happened in another case I worked on not long ago, where this person, they wanted to prove that he was actually the one using the email account because Google Drive had been used to store child pornography. And so they went through his email to prove that, he was emailing in job applications and things like that under his name to show that he was actually in control of and using that account, and that it wasn't just an email account that had a name similar to his or something like that. And so again, just because the email address seems to reflect their name or whatever, you always want to question whether the conclusions that are being made are supported in fact, or if we're just making assumptions about what people did. And then as far as matching pictures, I want to clarify that in many cases, law enforcement, when they're dealing with known victims, may actually identify people in the pictures based on, I've worked with this victim before and I know who it is. But in most cases, what they're doing is they're trying to identify known images of child pornography, and they can search for them based on the hash or digital fingerprint. And a regular hash is going to uniquely identify a file, so they will find exact matches. And then there's other programs that have some different abilities to find images that are similar but not 100% the same. And what they do in those cases is they try to digitally represent what the image looks like so that they can find copies of the same image that have been maybe resized or rotated or slightly touched up, things like that, and verify that it's not 100% the same, but it's a pretty close match, and we think these are all part of the same set, and they can use that to find these pictures on a computer, and they can use that to compare to what was being reported by the site or what they saw in the peer-to-peer program, so that they can confirm that the defendant was actually in possession of those materials. So next thing, a little diversion here, just to be aware how people collect child pornography. And I am not an expert on the offenders. This is from my own reading, and I thought it was useful information to share. But my understanding is that collectors of child pornography tend to hold on to those images and not delete them and cull their collections. They tend to curate and just continue to collect it. And part of the reason is that, this is their thing they're into. And those images are sometimes hard to come by, right? It's not like an adult pornography site where you could just easily go back to the same site the next day and find the same picture or video that they liked. They need to hold on to this stuff, and often they need to trade it with other people in order to get access to additional child pornography material, because often they need to share it in order to prove that they are also an offender. And so, I mentioned earlier, making sure that when they're matching between the activity on a device to a site, if they only have one or two of these images, it's likely that device is not the one that was actually doing the uploading, because these collectors are not going to be sharing these files and then deleting them all afterwards. They're going to hold on to it. And there's a good book out there, and it's in my notes, but it's not on my slides for you to click on. But it's available on Amazon. It's called Digital Child Pornography Practical Investigations. I got that name right. And the other thing to be aware of with these collectors is that adult pornography will often be mixed in with child pornography collections. And that doesn't mean that they weren't into child pornography. And, sometimes attorneys think, well, he downloaded adult pornography, so he must not have been into child pornography. And a lot of these people download both. But one thing to be aware of is that because they may be grouped together, it may inflate the image counts which go into sentencing, because and it varies by jurisdiction, but it may be at 100 images or 500 or 1,000 images that the defendant's going to get a heavier sentence. And so you want to make sure that any of the adult pornography images or videos are being excluded in those counts, because the guys that download child pornography often download both. And just to clarify, the reverse is not true. People who download adult pornography do not typically download child pornography. That's its own thing. So we talked a lot about NCMEC reports. We talked
So
about,
are you saying that that's kind of a fallacy?
There is a fallacy that people believe that, you know, if they're downloading adult pornography, they're not into the child pornography, and often they're doing both. But it's a one-way. But again, it's a one-way thing. It's the child pornography collectors are often into both, whereas the much larger population of people who view adult pornography are only rarely into child pornography. So I want to make sure we're clear. We're not conflating the two, just acknowledging that the people that are into child pornography are often, they often will view both or collect both. So we talked about the NCMEC reports, and that's how the tech companies tend to report these cases and which causes these investigations to be initiated. One of the other major ways that these investigations are started are with peer-to-peer file sharing. And peer-to-peer programs allow users to share files with other users without uploading them to a central server. And just to distinguish this, if I wanted to share a document with you, I could upload it to Dropbox, I could email you the link, you would go to Dropbox and you would download it from Dropbox, right? And so Dropbox is the middleman in that. And with peer-to-peer file sharing, they don't have that. You know, if you download a file from me, you download directly from me. Where it gets more complex is that, you know, if you're trying to download something from me, maybe a Blu-ray, I may go offline and now you can't download that anymore. And so what happens is that people share these files out, and, you know, I may rip a Blu-ray and I share it with many people. And once many people have downloaded it from me, then you don't have to get that file from me anymore. You can download it from them as well. And you can do that concurrently. So if you get on and obviously ripping Blu-rays is not legal, but let's say I've shared out a movie, I shared out the new Terminator movie. Okay, so I put this Blu-ray online and other people have started to download it and they have it in their file sharing clients, and then you decide that you want to find that. And so you go search for it and you start to download it, and you might get a piece of it from me and you might get pieces of it from 8 or 9 other people. And if any one of us goes offline in the meantime, you can continue to download from everybody else. But you're not going through any central server like Dropbox to get to it. And that matters for law enforcement doing their investigations. It also matters for defense, because you can share a file with most of these programs, even if you have not downloaded the whole file. So if you downloaded 10% of the Blu-ray from me, other people can download that 10% from you, even though you've not finished getting the Blu-ray file yourself. And that's going to be true of child pornography images as well. And so law enforcement use their own custom versions of these programs so that they can try to download the entirety of the file from one person. So when they say, hey, I downloaded this whole file from this IP address, they know that that person had the complete video or the complete picture. And that matters from a defense perspective, because if you don't have the whole file, you probably can't view it. And so you may not be aware of what you've actually downloaded. And often child pornography is uploaded onto peer-to-peer sites, and it may be uploaded and have a file name that does not indicate that it's child pornography, or that does not keyworded to show that it contains that, maybe misidentified as something else, or it may have a mixture of adult and child pornography terms. And so it's possible that you could find something online and start downloading it without realizing that it's child pornography, and then you're also simultaneously sharing that back out with other people. And so the law enforcement clients are supposed to verify that it only was downloaded from one person, but that's not necessarily accurate in all cases. I'm aware of cases where they've used their clients to download from somebody, and then when the defense examiners look at the defendant's device, they see that the defendant had not downloaded the entire file themselves, and therefore they could not possibly have shared the entire file. And so that's something you're going to want your examiner to look for. And the other problem with these is that people may not know that they're sharing things out. A lot of most computer users are not that tech savvy. And so they may download one of these peer-to-peer programs and use it to go and download child pornography or whatever else. And they may not be aware that they're sharing that back out with other people. They may not know how to configure their program to prevent that because it's turned on by default. And that was actually the crux of the issue in the case I talked about earlier, where we got an acquittal on cross-examination. We had a not very tech-savvy older person who had downloaded child pornography and admitted to that. He pled guilty to that, but denied knowing that he was sharing it out with anybody, denied knowing that it was in a folder called My Shared Folder, because he was able to view the files through the file sharing program. He never had to go into that to do it. And law enforcement, as far as I'm aware, didn't do any investigation or take any examination steps to prove that he'd opened them another way. And so, without getting into the weeds on it, through cross-examination, we were able to establish that all of the activity on his computer could have been explained without him having to manually navigate in that folder and be aware that these images were in My Shared Folder, which would obviously tell you that they were being shared with other people. And so by showing that there was at least a possibility that he had only interacted with it through the program and wasn't aware it was being shared, we were able to get an acquittal on the distribution charge. When we're dealing with peer-to-peer cases, you're going to want to ask what files were downloaded using the program, what they searched for, whether the files were downloaded completely. And that's important whether we're talking about possession or distribution or both, because if they haven't downloaded it completely, they may not know what was in it. They haven't viewed it, and there may be evidence of that. If they haven't viewed it, they don't know what was in it. And you're going to want to look at the search terms. So, you know, if someone's searching for, I don't know, anal hardcore or something like that, and there's no terms in there that would indicate that they were looking for pictures of children, that would indicate that they got this stuff by mistake. On the other hand, if law enforcement finds that they were searching for preteen hardcore, that's going to tell you that they knew they were looking for images of children. And it's going to be hard for them to deny that they knew what they were getting, even if some of the files maybe are misnamed or ambiguous about what they contain, because that search history is going to show that they were actually looking for that stuff. One of the other things to look at is whether they were downloading files one at a time or they were downloading large collections of files and downloading several files at once, where they may have done a select all and grabbed things that they thought were relevant to them, and grabbed a couple of things in the search results that they didn't mean to. And again, this is about trying to see if we can establish the user behavior to show that they were intentionally seeking out and downloading this material versus looking for something completely unrelated or looking for adult pornography and happen to come across some of it, which is probably a lot more common of a reality and a defense when we're talking about peer-to-peer than when we're talking about online pornography websites, where they're often professionally run businesses where they're keeping records of their models and stuff like that because they don't want to run afoul of the law. Which isn't to say that other things don't get posted at those sites at times, and there have been issues with that, but they are, at least generally speaking, trying not to host that material.
Are people getting caught with peer-to-peer because the police are in that peer-to-peer network? Is that how people are being caught on that?
Yep, and that's what we're going to dive into right here.
Oh, okay. Sorry, I keep jumping ahead of you. I apologize.
No, it's a good question. So law enforcement have their own versions of these peer-to-peer programs, and what they will do is they will use them to search for terms related to child pornography, and then they will download child pornography images from a single source. Remember, we were talking about that earlier. So they'll download from a single source so that they can prove later that, hey, I got this whole file from this person. And there are a lot of issues with that. One, law enforcement has generally been unwilling or unable to share the software that they use or to share the source code for the software that they use. And in some cases, they may be restricted by licensing agreements from sharing it. And there have been cases where it appears that they identified the wrong user with those programs. And I don't know if that was always true, or it may just be that the person decided to delete the things that they had downloaded or uploaded or whatever, you know, and get out of that. And so maybe the offending material just wasn't there when the police searched. But there have been cases where they've identified people as sharing child pornography material, and they go to their house and they collect their computers and their phones and everything else, and they don't have any. And so this is not just a hypothetical, you know, it's a real concern. Are they correctly identifying users in all cases? And they are correctly identifying users in at least some of the cases, maybe most of the cases. But there appear to be times where they are not getting the right person. And when they've been challenged on the use of this software, they are often unwilling to share or give up the software so that defense experts can examine it. I've never had a copy of it myself. And ProPublica did an investigation, and if you have my handouts, you should be able to click on this, where they found a number of cases that had been dismissed because they had been unwilling to share the software. And there is one case you can look up, United States v. Budziak, where the FBI used e-peer-to-peer, an enhanced version of LimeWire, and they downloaded child pornography images from the defendant's IP address, supposedly. And the defense was not able to get access to the program, and he was convicted. And it was remanded back to the court because they needed to make a determination on whether those materials would, in fact, have led to information that might have altered the verdict. Meaning, you know, if they were able to find that the program could sometimes, you know, identify the wrong user, then that would be relevant. And there's a lot of information you're going to want to get to investigate this. You're obviously going to want to try and get the software, and if they won't give it up, try to get the case dismissed on that basis. Get the user manuals for the software, get any investigators' records on what they did with that software. And one thing to be aware of is that often it is not local law enforcement that is actually using this to identify people, which makes sense, right? If I'm a police officer in Bakersfield, and I'm out searching for these terms, I'm going to get a lot of results that are people who are not in Bakersfield that are sharing these files. And so often these searches are done at a higher level by various ICAC groups or task force, and then they're referring out to the agencies underneath them to say, hey, we've got this guy in Bakersfield that's downloading these things, why don't you go investigate them? And that's not always clear. And in some cases, they may not be very straightforward about how that's actually coming about. And so the reports that the defense will get will indicate that the investigating officer in the local agency was the one who did all of this, and they won't share the information about that referral. And so it's important to ask for any and all notes that are used to support this and ask whether it came from an ICAC task force. And one of my colleagues worked on a case where local law enforcement officer had done all the steps himself, done everything, and they requested his time cards and got them, and found out that on the day that he did the search and identified this user or whatever, he wasn't working. So it had actually been done by the ICAC task force and handed down, and then he presented it as his own, and that wasn't the truth. So there's a lot of issues with this, and I'm going to give a shout out to one of my colleagues at another company. Since we're all NACDL members, if you go on to the NACDL forums, last August, Andrew Garrett from Garrett Discovery shared out a series of articles about these peer-to-peer programs and some of the hang-ups with this, and them referring cases through the ICAC task force and not sharing that information. So if you want to read a little more, he shared that information on the forums, and it's worth checking out. Okay, so that's enough about how the complaints come about. Now we're going to get into more general issues that should affect all child pornography cases. And first up is going to be reviewing the images. And we talked briefly about how these images are graded by the tech companies. Go ahead.
Before we go into this next portion, do you know what happened in that case? It was remanded, but then did they retry it and they were able to get the software?
No, as far as I know, they weren't able to get the software. I'm not aware of the software being handed out in any cases, although it may have been. But in general, they've not been willing to give it up.
Okay, so we don't know what the result of that, other than that it was reversed and remanded for, I'm assuming, a new trial.
They not necessarily a new trial, but for the district court to consider whether the defendant had been unduly prejudiced or whatever by not having access to that. So I don't know what the next step to that was.
Okay.
In that case. So when we're grading images, it's really important to talk to your forensic examiner about what you want to see in their report, and how you want them to share information back, because there are different sentencing criteria in every jurisdiction, and the counts that hit the different sentencing brackets may vary, and how images are counted may vary, because in a lot of jurisdictions, videos count for a higher number of occurrences than a photograph. So a photograph is one image, and a video might be counted as 10 or 50 or 75 images, which can quickly push the defendant up into a higher bracket in terms of sentencing. It's also the case that law enforcement may not be particularly thorough about sorting through the files and determining what is child pornography and what isn't. They'll say, hey, there's these files here, and there's child pornography in there. There's 1,000 files, so there's 1,000 instances of child pornography. And so if you're having your examiner go through, and your examiner may end up finding pictures that weren't even identified by law enforcement, you need to set the ground rules for that and ask them what you want them to report back to you. And generally, the way I would sort them is I would identify images that are clearly child pornography. We're talking about prepubescent young victims in sexual acts. Like, there's going to be no question that these images are actionable images. And then there's going to be some images that are maybes, where the people in the pictures are older. They might be teenagers. They might be adults. It's questionable. There's physical development there. And then there may be other images that are not relevant whatsoever. You got a picture mixed in there, and it's a dog out playing on the beach. There's no people in the photograph. It's not at all relevant to the case, and it shouldn't be counted. And then there may be other pictures that are maybe relevant to the case, but they're not pornographic. And this will happen when you have someone who's got a collection of pictures that are all of one victim, and they may have a set of, say, 20 photographs, and 12 of them are clearly child pornography, involved in a sexual act. 4 or 5 of them are posing and in some state of undress, and then the other, 4 images are not sexual in any way. It's just the kid standing there. And the argument for the defense attorney would be that those aren't child pornography, and that they shouldn't go towards hitting that higher sentencing bracket if you're close to it. And if you're way over the next threshold anyway, that may not be helpful, and it may not be worth the time. But if you're close, that might help get your defendant a lower sentence, even if they are determined to be responsible. So I'm not an expert in identifying kids based on physical development, so I'm not trying to give an expert opinion on these images. I'm trying to work with my attorneys to help them understand kind of just what we're working with, right? There's this many images that were clearly, bad things, and there's these others that are questionable that you might have another expert, challenge, or, maybe have a pediatrician say whether or not those are children. And they used to use something called the Tanner stages. And my understanding of the Tanner stages is they were not intended to be used forensically to identify the age of kids, and that they may be used in some places, but they're being used less and less and treated as not a reliable method for identifying the age of people in pictures. The things that I look for are
they're still
simpler.
being used in SANE kits. In the SANE reports, they've got Tanner stage, the ability to check the Tanner stage. So we're still seeing that a lot in sexual assault kits in the reports the sexual assault nurse examiner is filling out. Just
Gotcha.
throwing that in there.
No, that's good to know. So I'm looking for stuff that's a little more clear cut. So I'll see images where the supposed image of child pornography and the lady in the photo has a tattoo. Well, at least in the US, you can't legally get a tattoo if you're under 18. So that is an indication that that is an adult. Size and physical development, obviously, if they're clearly, small children, that's easy to identify. But there's others where it's questionable. It's like, maybe a youthful looking face, but it's there's pubic hair and the person is physically developed, either physically, a large adult sized penis, large adult sized breast, that sort of thing. And at least there is some question about whether that could possibly still be a child, although it might be, because people develop at different rates and at different sizes, but at least it's clearly not a prepubescent person in the picture. And then body piercings are another indication that someone is older. You can get body piercings under 18, but there's still some age restrictions around that, and you're going to see fewer minors with body piercings than you are adults. And then the other thing is there may be watermarks and copyright notices, and that works both ways. I've seen images of child pornography where the person distributing them has their own kind of brand. They may have a certain name that they give to their collections, and they'll put them on there, and that identifies that they are clearly child pornography. But then there's other cases where I've seen photos that were lumped in with child pornography, and they are watermarked or stamped with the name of an adult website that produces legitimate pornography, keeps records, that sort of thing. And so that's going to tell you that those aren't actually images of child pornography and shouldn't, again, be included in the charges or in the counts of those images.
Maybe you're going to get to this, but do you also look at like pixelization to see that a head was not photoshopped onto a body?
I don't do that. That's a little more specialized on the image forensics, and there are people who specialize in that. I would end up referring that out if there was a question about it in my cases.
Can you just obviously tell if they're photoshopped, or because you hear about that.
There may be some that are visually obvious, but if it was done well, it might not be something that a layperson could identify. And we're talking about image analysis. I would consider myself a layperson in terms of analyzing images. I may spot an obvious problem, but my expertise is more in the operating system and the underlying data, the file system data, that sort of thing. So if there was a question about whether the images themselves have been manipulated, I would end up asking to bring somebody else in to look at those and see if they've been manipulated. That answer that?
Yeah, I just you hear about images that they're actually not child pornography because of the photoshopping, and so I just wondered how do people check the images to make, because I would think that if you're going to court on these very serious crimes, that you want to know for a fact that this is actually a child that you're looking at.
Yeah, absolutely. And there are cases where, obviously, when you're dealing with images that concern younger children, where it's obvious that it's just a child, period. But when you're dealing with child pornography that concerns, teenagers who are close to adulthood, it's going to be more questionable. And obviously, you could have the face of someone who's underage put on, say, like an adult model. But if we're looking for image manipulation, I would end up referring that out. In fact, I'm working on a case right now where I ended up recommending a different expert to do the image analysis part of that, because there was a question about whether some photos were altered.
Yeah, that answers that. Thanks.
Okay. So the other thing to look at is, are the images actually pornographic? And there's going to be different criteria by jurisdiction. Obviously, when it's an actual sexual act, it's going to be considered child pornography. Images that have posing and maybe undue focus on the private areas may not fall into the same category. And so it's important, the attorneys should know these distinctions in their jurisdiction when they're handling these cases, and if they're not familiar with them, you should be researching them. But it's important to make sure that your forensic examiner knows, because like I've worked on cases that are across the country, and I don't know the rules in every jurisdiction, and so I'm looking at the attorneys to tell me, hey, these are the rules here, and this is how I want you to report this information back to me so that I know what I'm working with. And then obviously one of the things I look for in these collections, which I mentioned earlier, is there may be images that are part of a collection of child pornography that are not themselves pornographic. It may be like just a headshot. And so if you're close to one of the thresholds for sentencing, you're going to want to identify those images separately so that the defense attorney can argue that the number of images that are actionable is below the threshold. So talk about number of images being in the category. Age of the victims is often a sentencing criteria as well as the content. If there's like sadistic acts and things that are in the pictures, and there's different definitions for that, then that could impact sentencing as well. And so you're going to want to know if that is in there. Now, in terms of quantity of images, there are technical questions around that. And so I already talked about, they may look at 1,000 images and say, oh yeah, there's child pornography in there. It's all child pornography. And so you can look through the images that are clearly not and say, look, these images are something else, pull those out. But the other question that comes up is, are they all unique images? And different jurisdictions have looked differently at the question of how do we count duplicate images. From a technical standpoint, and what I would want attorneys to be aware of is that there are often duplicate images that were created without any specific action by the user, because like when you download pictures, your computer may create thumbnail images of those so that you can like do the gallery view in Windows, and it creates those thumbnail images without you telling it specifically to do that. And there may also be situations where a file got downloaded, to your temporary files when you're viewing something online, and then you save it later, and there may be more than one copy on the hard drive, even though you only tried to possess one copy of the image. And then if things get moved around or get moved off the device and back, there may be copies of that image that exist in the unallocated space on the drive, the free space on the drive. And so you might have several copies of an image, even though the user only had at any one time one live copy. And if you were, depending on your jurisdiction and what the rules are on it, you have conversations with your forensic expert about how those duplicates came about. And I usually give the attorney several different counts and say, look, we found 500 images. If you exclude the duplicates, there's 300, et cetera, et cetera. And I'll give them different categories so that they know what they have to work with when they're arguing their case, maybe trying to get a plea deal or trying to argue sentencing if the defendant's convicted. Under California law, and this is just an example, videos are considered 50 images, and that's a pretty typical kind of rule. And the amount is going to vary by jurisdiction, but that can quickly push a case up into a higher sentencing threshold when there's a lot of videos or even animated GIFs, which may, in some cases, be considered as videos because they play a moving image, even though they tend to be very short, like 1 to 5 seconds. And we talked about the other questions about whether they're underage or whether they're pornographic. Talked about duplicates.
What is a GIF considered?
GIFs can be animated GIFs where they're moving images, or they can be just a static single picture. And I don't know that I know at least in some cases they are treating the animated GIFs as videos, even though GIF's not typically considered a video format, because it's a moving image, right? And so if you've got an animated GIF that plays for 5 seconds, each frame of that, the prosecutors would like to consider as a different image, and that's why these sentencing laws have counted videos as being more. And so I would guess that typically the GIF is going to be lumped in with that, but I'm not aware of any case law that has decided one way or the other, so I don't know if that's actually a legal issue that comes up. But I mean, the common sense argument would be, what's a video, right? A video is a moving picture, and a GIF's a moving picture. So more than likely, those are going to be considered videos.
Okay.
Now, when we're talking about duplicates, I hit on this a little bit and talked about the fact that the computer may make more than one copy of something when it's doing thumbnails, but there are lots of technical exceptions in both directions as to whether something is a duplicate or not. So for instance, on Windows Server operating systems, you can make several copies of a file, and the operating system will deduplicate and make sure that it doesn't actually store that file several times. Instead, it'll move it to a central location, and all of the other copies will just reference that. And there's kind of a complex system for identifying duplicates and doing that. And then on Linux operating systems, it's not a lot of offenders are going to be using Linux, although the Android phones, actually, Android was based off Linux. But they allow a file to live in more than one place, where there's one copy of the file, and it could have 10 different names, and they all appear to be separate files, and it's actually only stored once. And these systems may be used on different different electronic service providers. You know, home users aren't likely to have these server operating systems, but Google is and Facebook is. And so when you're storing an image on some of these systems, even if it appears to be multiple copies, there may not actually be multiple copies. They may all just be linked. And then the other direction of that is that if you upload something to one of these online sites, they may actually duplicate it and store copies of it in 10 different regions, because they want people to be able to access their sites quickly. And so you upload an image to Tumblr, and they may copy that to a data center in California, a data center in Texas, a data center in Virginia, because when anyone goes to that website, there's not one copy of the website that they're sending them to. They want them to go to the most local copy. So what is a copy or what is a duplicate is actually a really complex technical question. And I haven't really seen the courts get into that yet. But a copy of a file is hard to define technically, and there are probably some arguments to be made if you have a client with a lot of duplicates that may not be.
If you're storing it to a cloud and the cloud is shared, does that count as distribution?
That's probably going to get charged as distribution, and I mean, the cases I've seen when people have uploaded to sites and they're like publicly shared, they've treated it as a distribution offense. If it's not public, it may vary on jurisdiction whether it's considered shared because you're moving it onto someone else's system, but no one else actually has access to it. And I think there's a lot of questions there that have yet to be determined in any significant way legally. But looking at it from the technical perspective, it's hard to say whether something has been duplicated or not. And with things being shared, you know, these sites are reporting when things are uploaded, but they're often not reporting whether anyone actually downloaded it. And so in most cases, I think what people are looking at is, was it publicly available? But I don't know that they're always basing it on whether someone actually grabbed a copy of it. So next up is a fun thing that comes up, and that's the Trojan horse defense. And the basic idea is someone is charged with downloading or uploading child pornography, and they didn't do it, a hacker did it, a virus did it. And it's the kind of thing that I think a lot of defendants come up with on their own because it sounds good to them and they don't want to be responsible for it. And it has been used successfully in a number of cases. As far as it actually being the cause of someone downloading child pornography, I think that's probably very rare. I'm only aware of one piece of ransomware or malware that ever actually distributed child pornography. So the fact that it's being used as a defense is separate from the fact that it's not actually very common. And the thing to remember is most of the people writing malware have no association with child pornography. And they're often not looking to draw attention to themselves or at least not draw attention for that. They're looking to carry out their business, or they're looking to cause, some destruction, but they're not looking for that. And so this is a screenshot of the
You'd be able to find that out though when you're looking at the actual computer itself, is where that if that computer was hacked.
Yes. Yeah. You're generally, may not always be able to determine something, but yes, that's something you can look for. And generally, there's going to be evidence if the computer's been compromised or if it's infected or whatever. So this is a screenshot. Obviously, the images of the children are blurred out. And this is a piece of ransomware that came out several years ago, where it installs this program on your computer, says, hey, we know you've been viewing illegal content. And then it showed screenshots of the actual images of children and said, hey, we know you've been doing this. And if you pay the fine now, you won't be charged. And they basically just display these images to you to threaten you into paying a ransom, even though up to that point you had not downloaded any child pornography. And so this is what it could look like, this kind of situation if you have someone who actually did not intend to download any child pornography. And the first thing you can do, and I'm looking at some of the prosecution's perspective, thing that they should do to eliminate this, because the defense attorney, if the prosecution hasn't looked into it, this is a valid defense that you can bring up. What they should be doing is trying to show that malware was not present on the device, to actually go out and look for it and say, hey, we looked and we couldn't find any malware, any Trojan horses, any viruses on that computer. Or if there is malware, to research it and show that it's not ever been associated with child pornography. So if someone's got some browser search bar add-on that was installed on their computer that gets flagged as malware, you might be able to show that, look, this thing's associated with, these various advertisers. There are no reports of it ever being used for child pornography, and there's no reason to think they would ever, generate child pornography. It's just something that people don't generally want on their computers. So if they didn't do that, then it's something you can bring up. And if you think that the malware actually was responsible, reverse engineering a malware is its own discipline. Some forensic experts are capable of doing it to some degree or other, but for the most part, it's a separate specialty. There are people who do both. And I have some basic skills in this, but if we were looking to prove that, the malware actually was responsible, this is the kind of thing where I'd probably say, let's reach out to someone who just reverse engineers malware all day long and get them to help us prove it. Same concepts apply to hackers. Most hackers have no connection to child pornography. They're in it to make money, or they're in it to score political points. And most child pornography distributors are not hackers, though some of them may have technical skills. And so the thing to think about when your client's bringing this up, and I say to think about this because I want defense attorneys to be realistic about what's going to work or not. If your client is suggesting that someone else is responsible, you got to think about what's the motive, right? If they've got an ex-spouse who works as a professional penetration tester, well, hey, there's somebody with motive who could actually maybe pull that off. But if they have no idea why anyone would want to put that on their computer, and there's no reason to suggest that anyone was trying to get them in trouble for that, then it's going to be less likely to be successful. And what the forensic examiner on the prosecution side, or someone like myself, if you hired me to do a full exam, we're going to be looking to see, is there evidence that ties the user to this activity, to show that they were actually responsible for it. And this is important in a lot of cases, regardless of whether there's some suggestion or malware, but we're going to look for search history. What did this person search for when they were online or on their peer-to-peer program? What files had they opened recently? What did they have stored on their storage devices? It's hard to say that, the malware must have downloaded this child pornography when you've got like 4 thumb drives that you've been backing it up onto manually. It's going to be real hard to argue that you didn't know all that stuff was there. And so law enforcement should be establishing a timeline of activity establishing what was uploaded or shared, the account history, when the computer was on, when the user was logged in, where these files were stored, were they squirreled away somewhere, were they in the My Shared folder for the peer-to-peer program, were they in a folder that was on the desktop, were they transferred to another device, and those things are going to make your suggestion of a Trojan horse defense not very viable, right? Because they're proving that the user was interactive with this material and was responsible for it. And it's not going to be realistic for them to say, look, it could have been malware that did this. I have no idea how this got on my computer. Whereas if all these things are missing, if there is no evidence that they ever did any of this, these files just showed up, then that's a more valid argument. One of the urban legends that comes up is that pedophiles will remotely access other people's computers to browse child pornography, and that's not how it works. People aren't connecting to your computer and browsing this stuff through your web browser. If this is in your browser history, it's probably because you've been browsing child pornography. They may use services like Tor, which we talked about earlier, where someone's operating a Tor exit node and gets blamed for something like this, and that's possible. But as far as interactively using someone else's computer, I'm not aware of any cases where that's happened, and it's at least not a typical thing. And it's also not the case that pedophiles are hacking into other people's computers to store their collections, and that doesn't really make sense because they want it to be available. Now, where this could happen is where you have online accounts versus computers. So hacking into your computer and storing their child pornography makes no sense, especially your computer's not online all the time. Hacking into someone's Google Drive account and storing it there makes a lot of sense, right? They hack into this account, they may store their material in a couple of different accounts, but it makes sense because Google's online all the time, right? So as long as they have access to the account, that stuff's going to be available. And then they can store it in an account that's not associated with them so that they're not getting blamed for it. And we actually had a case similar to that come up with a school district that I work for. And what they did was they applied to a college using fake information and never registered for classes. They just applied so that they could get an email account and a Microsoft OneDrive account. And then they used that OneDrive account to store child pornography. And the system administrators were alerted to it because they exceeded all of their storage capacity, and that was what they were allowed for those accounts, and reported to the police. But then when they investigated, the person who was uploading all of that was actually in, I think it was Vietnam or somewhere, so they weren't local. So this is definitely the kind of thing that you come up with when we're talking about cloud storage, but not so much when we're talking about personal computers. Again, I'm not aware of any cases where that's actually happened, and doesn't seem likely. The thing that's more common, and I'm aware of cases where this really happened, is where the roommate did it, or someone else in the house did it. And there are a number of real cases where, the police initially were looking at one suspect, and these materials were downloaded or uploaded from somewhere, and they investigated, they get the computer, and ultimately, and often it's the defense experts that are figuring this out because the law enforcement investigations aren't super thorough. Otherwise, we wouldn't know about these cases because they go after the correct party in the first place. But they'll end up initially charging someone, maybe the owner of the computer, and it turns out later that it was the roommate, or it was the ex-spouse, or that it was the ex-spouse's new boyfriend. And so this is where timelines are really important, and determining, my client's getting charged with this, these things were downloaded in April, where was the computer in April? And there was one case that was presented at a conference several years ago, it wasn't my case, where this guy was charged with downloading child pornography, and it was the wife or the ex-boyfriend that turned him in, the wife or her new boyfriend that had turned him in. Problem was the timeline of the activity showed that all of this stuff was being downloaded in July of whatever year, and he and the wife had split up, and he moved out in April, and the computer stayed with her. So even though this stuff was being downloaded and accounts were set up in his name to do it, and it was all being downloaded to this computer, it definitely wasn't him because he wasn't in the house and hadn't been in the house for months. And it ended up being the wife or the new boyfriend were trying to basically frame him up and take him out of the picture. And it ended up, I think it was the boyfriend that ended up being ultimately charged, and the original charges were dropped. But this is where you really want to prove that not just that a device was responsible, but that a particular person was responsible, and take the steps you need to put them at that computer and show that they carried out this activity. And so again, a lot of the things I'm saying right now, I'm presenting it from like the investigator, like prosecutor's perspective, like how do you prove this? And the defense side of it is all the opposite, right? Like, were these steps done? Are these things in place to prove that the defendant did this? Because if you've got a house where there's, 2 or 3 or 4 people who might have been responsible, and you can't prove who was actually sitting at the keyboard, then you don't know who's actually guilty of downloading this material. And so I think this is a defense that's probably more technically supported than the Trojan horse defense, because this is going to be true in practice more often than the other. They're both used successfully in real cases. And so when you're looking at a computer with multiple users, you want to try and prove who was using the computer at that time. And one of the things that I used to do when I was doing internal cases for a school district is have a teacher that went to some pornography sites, right? And they would say, oh, man, I let my students use the computer sometimes. One of them must have gone out and downloaded this stuff. And I'm not aware of that ever actually being the case. All the ones that I worked on, we would develop a timeline and we'd say, well, you've got a free period, 5th period, and every time we see that you've been downloading pornography, it was during 5th period when you had no students around, right? And prove that they were the one that was actually misbehaving. On the other hand, we did have one case where an athletic coach's computer had been used to download some pornography, not child pornography. This is just a workplace offense. And we looked at the timeline on what we saw in the downloads from our firewall, and also the history from the computer. And it was all actually just one session. And so we talked to HR, we talked to the principal, and found out that this athletic coach was not on campus that day. They had an athletic event. They'd left on a bus at 5 or 6 o'clock in the morning and didn't get back until 5 or 6 o'clock at night. This happened, in the middle of the day, and determined and I think they eventually found out who it was by doing some personnel interviews, but it couldn't possibly have been this coach. So before anyone actually got accused, in person, we had determined that he could not have been responsible for it, and we were able to show that it was someone else accessing his computer. And what was happening is he was leaving it unlocked in his office, and some other staff person was coming through and hanging out in there and using it for that purpose. And so by being thorough on that, we were able to make sure we had the right party in the first place. And then what's going to happen when we're defending these cases is we're going to be looking at, were they thorough? Did they actually follow up on everything and make sure that it was our client, our defendant, who is responsible for this, or did they just go full steam ahead and start throwing charges out and not actually connect all the dots? And on the cases I've worked with, it's funny, the one that I think was done the most well done, that was most thorough, I got the impression that the forensic examiner that was working on it actually didn't have that much technical experience. They seemed to be a little newer to it, and they followed up on absolutely everything. And there wasn't a lot of room to suggest that the defendant was not responsible. It was a really tight case because they checked every box, they connected every dot, right? Like there just wasn't any room for doubt on that. And then I've seen other cases where the examiner is much more technically competent, has more experience, they have a lot more training and stuff like that, and they just don't follow up on things. And so there's lots of what if that, and what if this other thing, what if this happened? What if this person did this? And it's not a tight case, right? There's lots of possibilities for some of the information to be wrong, or for another person to be responsible. And so All these things I've been covering for the last 45 minutes or an hour have really been more investigator focused, but that's what you should be looking for, what you should be asking your examiner to look for. Have they connected all these dots? Have they done the timeline? Have they proven that it was my guy that was sitting there? Or have they, found a little bit of evidence, hey, it might be my guy, and then they take it to the prosecutor and it gets charged, and it's actually not a very strong case. So one of the last things I wanted to talk about is deleted files in unallocated space. And this is really important because there are going to be cases where someone gets charged and there are no files of child pornography that are still on their computer. They're charged with uploading and downloading this stuff, and anything that's found is in unallocated space. And this could come up too, where it's been reported by like a computer repair company or something who's doing data recovery and finds some of this stuff. And the thing to understand, when you have a file on your computer, there is a record that says this file exists. It has this name. It was created on this date. It takes up this much space, and here's where to find it, right? And then there's another spot on the hard drive where that file is actually stored. And if it's a big file, it may actually be broken up and it's stored in several different places in pieces. And when a file is deleted, and this varies a little bit by system, it's usually not erased. What happens is the record that says that file exists is marked, this file doesn't exist anymore. And those records are generally stored in one location in a big table. And by marking that file that it's deleted, that record entry can be reused to create a new file. And so when that record gets marked, the record's still there, and you can still get to it with data recovery or with forensic software, and the storage locations are still out there. That data is still in them. But if you are browsing on a computer, you're not going to see that file anymore. You can't access it. You're no longer in possession of it. We're talking about child pornography cases. And so when you run the data recovery, you may be able to get it back, and eventually that file may become unrecoverable in a couple of different ways. One, as new files are created, those records that were marked as deleted can be overwritten. A new record can be put in that slot that identifies a new file. And now, even though the data may still be floating around out there, that record's been overwritten. It's kind of like replacing an entry in a card catalog in the library. And I think I was probably the last generation that still used the physical card catalog instead of a computer to look it up, but we had a card for each book. I know you'll remember those, Laura. And
Absolutely.
So it's kind of like, marking a card and saying, look, we're taking this, we're getting rid of this book, but I'm going to set this card over here and we'll reuse it. We'll just put like a sticker over the top of it next time we have a new book to put in, right? And until we put a sticker over it and write out the information for a new book, not that any libraries actually did that way, they probably just printed new cards, but still, we could do it that way. Until someone puts a sticker on it and writes the information for a new book, you can still see what the information was. And then separate from that, the file is still floating around out there somewhere until other files get stored in the same locations, and that's independent of the record. The record and the file storage are two different things. So it could be that the record gets replaced and the file is still out there, and it could be that the file gets overwritten and that record's still there, marked as deleted, but now there's a new file in that spot. And so if the record is still there, you're still going to get the metadata, the timestamps on the file, whether or not you can recover the actual file. And if the file is out there, you can get the content back, even if you can't get the record back. So when we're undeleting a file that we have the record, we get that metadata. We can tell what it was timestamped. But there's another process where we just search the whole unused area of the hard drive and try to recover files. And that's called file carving. And we're looking at every storage area on the drive that's not currently in use. So like when you go into your computer and you go to My Computer and you see your C drive and it says, hey, it's 30% free, or there's 100 gigs free or whatever, we're looking through that free area and looking for patterns that would identify different types of files, like a JPEG image. So, the computer sees a certain pattern. It's like, okay, this looks like a JPEG image. I'm going to grab this area and I'm going to save it like it's a picture, and we'll let the forensic examiner review it. And when you're doing that, you are not getting the metadata back. You're just getting the picture itself. It's not telling you when that file was stored there. It's just telling you that it existed at one time. And so these kinds of card files are basically circumstantial because you can't prove on the basis of that alone that the person who owned the device was ever aware of those files existing there. And so, curious story, and this doesn't involve child pornography, it just involves data, but I purchased a box of USB thumb drives from Amazon, and they were new, or they were said to be new. And when I got them and started using them, I found out that half of the drives already had data on them, and actually they had all been used by a professional photographer to store the photos from some sort of dance recital. And so half of these drives have the photo set from this dance recital, all watermarked and everything, on my new hard drives or new thumb drives. And so they weren't as new as I thought, right? Somebody had actually had them and used them. Maybe they returned them, but they were being sold as new. They had data on them. And on some of the drives, it had actually been deleted and was in a trash can folder because it was done on a Mac. And on one or two of them, it was still live. But, you know, I wasn't responsible for those files being on there. And if they'd been reformatted or deleted or whatever, those images still could have been carved off of the device. But I would have had no way of finding out they were there except to do my own forensic recovery on them, which I'm not typically going to do when I buy new storage devices.
That's
and it may also be the case. It is. And it can be the case, too. You know, you buy a computer at the store, and it's the floor model, right? And different people have been using it in there. And whether it's a floor model or not, it might have been hooked up and turned on at some point by one of the, technicians or salespeople, working in that area. And so someone may have fired up that computer and done things with it before it ever got to you. And that stuff may have all been erased or that history cleared out. And those files may still be able to be carved off that drive. So when we're dealing with a case where the evidence is just stuff that was recovered in that way, the argument is going to be that my client, my defendant, didn't know that that was out there. And that is, again, not just a theoretical thing like that. That is a very real concern. When you buy a device, you don't necessarily know what has been stored on it already, even when it is a supposedly new device. And so, again, the burden is on the prosecution, and you want to make sure they meet their burden to prove that your defendant knowingly possessed these files, accessed these files, downloaded these files, shared these files, because if they can't do that, then you may be able to win your case. So the key point on this is that when you find a file in unallocated space and they don't have any timestamps, it proves that it existed at one time. It doesn't say who created it, when they created it. There's not going to be file permissions that says that, Joe owned this file or user one owned this file or whatever. It's going to just be the content and none of that context. And so it can be before they took ownership.
What about, let me interrupt. What about if you're using cloud storage? I don't know what, Google Cloud Storage, let's just say, and you erase the files on cloud storage. Since that's on a server, wouldn't there be a way, do those really get erased? Do the files really get erased on a cloud?
Sure, maybe. It probably varies by cloud provider to cloud provider, but they have their own backups. And so they may have backups of things that have been deleted that they can still access. And they may have backups of things that have been deleted that they no longer have a good way to access, but it may be floating around out there somewhere. And you're never going to get a warrant or subpoena to get them to turn that up. It's really going to matter whether they have an accessible backup or not. But with these cloud providers, they're provisioning, deprovisioning, and reassigning this stuff all the time. So if they did data recovery, I'm sure they could find things out there that have been deleted and are still around. but the biggest concern is going to be, were these files still stored on my client's cloud account, or were they still recoverable on that account? It may be that the provider keeps things that are deleted for 30 days, right? And so they may be able to recover that for 30 days. And then beyond that, it's lost. They, even if it's still floating around out there, they don't know how to access it anymore. But yeah, I mean, it could be floating around forever.
Good to know.
So that is the end of the presentation proper. If people have downloaded my slides, I've included a few things. There is a law review article that talks about some of the legal issues that came up in my presentation. It's called Who's the Witness to an Internet Crime? And there should be a clickable link from the PDF version of the slides. If not, you can screenshot this, and it should be pretty easy to find that article. It's available online. And then I also have some articles that are available online, and these also should be clickable links. But I have an article, and these are all hosted on the website HG Experts. And I have one about the cyber tip line reports. Covers a lot of the same material as we covered in this presentation, but maybe easier to refer to. There's another article. It's about computer forensics and sentencing criteria. And this isn't a legal article. It refers to, I think, one or two laws just to make the point. But it's really about what I was talking about earlier, about communicating with your forensic expert and making sure that they, or me, if you're working with me, understand what applies to your case and what you want to know, how you want information to be reported to you. And then an article about identifying people using an IP address and some of the hang-ups that come up with there, and we talked about that today. And then understanding deleted files and what they mean. And it's a different explanation of this last part that we just talked about, of what it means to recover a deleted file or to delete a file, and what it means to carve a file out of free space and find it. Because that, again, a situation where often you're missing the context, and if there isn't other evidence that the defendant knowingly downloaded or possessed this stuff, then he may in fact not have knowingly ever possessed this material. Maybe something that's been on his hard drive since before he owned it, and not something he's responsible for.
Thank you so much,
Okay.
Stephen. I really appreciate you joining us and getting this information out for the Credits Without Contacts. I appreciate it.
Thank you very much for having me. It was been wonderful to do. My voice is getting a little hoarse now, but I appreciate you sitting with me for the last 2 hours, and for all of our people that are watching this at home later, I appreciate you sitting through 2 hours of this. I hope it was useful. If you have trouble finding any of the cases or other things that I referred to in here, you can shoot me an email and tell me what you're looking for, and I will get it to you as fast as I can. I'm not going to add you to any email list or anything like that. And if you have any questions about the presentation, or if I've misstated any of the legal issues, feel free to hit me with an email for that as well and let me know. And again, I won't add you to any list. Be glad to hear from you.
Well, thank you very much. And we will be, I'm sure, I'm going to say this, and I know that Gerald is going to probably hit his head when I say this, but I'm sure that the CLE, we've got Stephen's presentation for you to download. And so with this presentation, you'll also have a copy of the presentation as a file that you're able to download to get all of this great information that Stephen's provided these references. So thank you all again. And I would just like to say, wash your hands, stay safe, and wear a mask. But everybody be careful, be good, not too good, but be careful, be safe. And thank you very much, Stephen.
Thank you very much for having me. I appreciate it.
Bye-bye.